Good afternoon and welcome to episode number 34 of At Your Service with Haber and Martinez. Good afternoon, Mr. Martinez.
What does your shirt say? What does yours say?
Pie. Today is Pie Day. Happy National Pie. There's nothing like the man in black. He's my favorite.
Johnny Cash.
Folsom County Blues.
Interesting story about Johnny Cash that everybody gets wrong. A lot of people think he was in prison. He never went to prison. He
did go to prison. He went there to go play a concert.
Correct. He was one of the first guys ever to do that. That's why it's like a big deal, because he felt bad that they weren't getting any entertainment. So he went.
By the way, it's an amazing album. The live at Folsom County Jail is unbelievable.
I just think people should get credit where they do. Look, that was a big step for him. I'll give you another pet peeve of mine. It has nothing to do with the law, but it's just my pet peeve. Jackie Robinson deserves all the credit in the world. It must have been incredibly difficult for him to be the first. Well, he's technically the second black player, but that's a story for another time. The first black player in the modern era of baseball to play. But nobody ever wants to give Branch Rickey any credit. You know how much shit that guy took for bringing him up? And Pee Wee Reese, you know how many death threats Pee Wee Reese got for being an N lover? Every white guy on that team went to, well, not everyone, but most of them went to bat for Jackie. And they were all getting death threats, true. And I think it's important for everybody to notice these things. It's not just one guy. It takes a team. And there's a lot of people helping and putting in effort. And they deserve the credit. So anyway, that's my PSA.
Apropos of our T-shirts, our respective T-shirts, let me say this. Number one, as for myself, today, March 14th, is in fact Pie Day. So happy Pie Day to everybody. I hope that you will enjoy a slice of whatever it is that rocks your world. I don't judge. You can go with fruit. You can go with nuts. You can go with pizza. You can go with meat pies. You can go with empanadas, whatever you want. Whatever rocks your world, just do something good for 314 Pie Day. The second thing I will say is apropos of your T-shirt, again, Folsom County Jail, that's what our show is about today. It's right. About jail. It's about jail. It's about prison. And what I have entitled Boons, Banes, and Bypasses. What are boons and banes? Those are pluses and minuses, right? And there are certainly some pluses and minuses if you have no alternative between jail and prison. And then bypasses would refer to the acumen that you and I and folks of our ilk have developed to try and keep people either out of those settings or to minimize the time that they have to spend inside of them. So with our shirts and that introduction, let's sink a little bit into it. Let's start with, as I listed on our promo, we can start with differentiating why do we have jails and prisons? What's the difference between them? Why is there a distinction? What is it, and what difference does it make?
Okay, so you want to take it as far as like the legal stuff, misdemeanors
versus
felonies, and then we'll get into the strategy of why sometimes we try to do what we do.
So I want the audience to understand crimes are categorized into various different categories, but the most relevant categories, at least for purposes of this discussion, are felonies versus misdemeanors. A misdemeanor, and again, this may vary in terms of linguistics from jurisdiction to jurisdiction, in terms of it may be different in New York or in Washington State than it is in Florida. But in Florida, a misdemeanor is any crime that is punishable by less than a year, meaning 364 days or less is the maximum punishment that you can get. That is a misdemeanor offense. Anything that's punishable by a year and a day, anything more than a year, is a felony offense. And so that's one of the main distinguishing characteristics that we can draw a very plain line in the sand to differentiate between felonies and misdemeanors. There is a level below misdemeanors as well, and that would be infractions or ordinance violations that carry no possibility for jail time but have other penalties. Sure. So while you can't get time, you can get hit in the pocketbook, you can get fined, you can get community service. There's all sorts of other types of things.
Your license can get suspended.
Or other types of licensing, professional licensing as well. You know, so there are those collateral effects. But within those two categories of misdemeanors and felonies, there are varying levels. So there are second and first-degree misdemeanors, first being more serious. And in felonies, there are thirds, seconds, firsts, first-degree PBLs, punishable by life. We talked about those last week when we were discussing Arthur hearings. And then at the very top of the felony food chain are what we call capital offenses, which are offenses punishable by death. So if you understand the difference between those things, we know going into every case, just based on the charges themselves, what the maximum possible sentence that somebody can get given their charges is. So the key here, well, I guess there's a lot of keys, but the first key is, and here's a pro tip, the sooner that you get a competent defense lawyer working for you, the better.
Correct.
Why? Because police officers make arrests. They make arrests mostly in the moment. Again, we're going to talk about different nuances, like between federal and state, between specialized investigated crimes and the most common types of crimes, which are those sua sponte, in the moment actions, which nobody plans or prepares for, but which just kind of happen. And so whatever that is, that circumstance that officer friendly or officer unfriendly, as the case may be, decides to charge you with and book you into the jail, may or may not be the charge or charges that you ultimately face after a prosecutor has reviewed them and decided what, if anything, is appropriately filed. Why? Most cops are not lawyers. Some are, most aren't. Most cops don't know the law the same way that defense attorneys and prosecutors do. Some do.
Plus, they make an arrest under a different standard. So even in the best case scenarios, the officer may have every single piece of evidence he needed to make that arrest because their standard is probable cause. And we've talked about this before. When I used to train, the easiest way to remember it is it more probable than not that the crime occurred? But once the state attorney gets the file, they're ethically bound. Some do, some don't. I'm not saying they're doing it on purpose. I think sometimes they just don't understand. They are ethically bound to not file it unless they think they can prove it beyond a reasonable doubt. So it could be that the cop had every right to arrest you. And that very same prosecutor, if he was a cop, might have arrested you, but he gets it now and he looks at it and says, yeah, this is still not enough to prove beyond a reasonable doubt. And he may have to drop some of the charges or the whole case together.
Well, and again, also depending upon the situation, right? Let's go with what I would call the most professional law enforcement, and that would be on a federal level. Generally, the feds don't just make arrests. It happens periodically. Like, for example, a Coast Guard stops a boat and they just pop people. Right. But as a general operational principle, the federal government expends an awful lot of time and effort in investigating offenses, and they will let crimes occur for weeks, months, years even, while they continue to gather all the information, document all the information, provide it 6 ways from Sunday, upside down, inside out, on an angle, perpendicular, horizontal, videotaped, audio taped, everything that they hand off to the United States attorney, who oftentimes is involved in these investigations and assisting in the choreography.
Almost all the time they're involved.
And we do see this, and you've mentioned this many times about state court, where we do see this in specialized units where the police are conducting investigations. But again, that's the vast minority, at least of state court cases. Right. In most state court cases, the cop knows what he knows in the moment. She or he makes a decision based on that information, which may or may not prove to be accurate or complete by the time the state attorney gets on it. So again, that pro tip, if you have a defense lawyer working on your case while the state attorney is in this pre-filing process, in this purgatory, trying to decide what, if anything, should be filed, when you have a creative, competent, ethical defense attorney zealously advocating on your behalf, you may be able to affect those charges and do yourself a favor right out of the gate. So I'll give you a good...
If I can interrupt you, one of the things that right out of the gate can help you in that situation is reducing your bond amount. Because if they charge you with 7 charges, say the cop puts 7 charges on there. Well, for sake of argument, there's exceptions, but generally speaking, there's a standard bond. If you get a good lawyer early enough that can talk to the prosecutor and say, listen, I know you think, whatever, but you have there's no way you can prove these 3 charges to a reasonable doubt. And you're never going to be able to get it now for whatever reason it happens. The prosecutor, if you've got a good defense attorney who treats prosecutors with respect and treats them like professionals, they'll be glad to talk to that lawyer. And that they might say to the lawyer, you know what, you're right. Don't worry. When I'll file the charges, I'll reduce those. And you might be able to say, can you do it now so I can get him a bond? And they might. They might just say, okay, listen, set it tomorrow. I'll tell the judge I'm no actioning those, but I haven't made a decision on the others. And if he wants to bond out on these 4, he can. So it's always a good idea to try and get your lawyer in as early as possible, even just for that, a cheaper bond.
Or different or reduced charges. So we get this process, and as lawyers, because we've been doing this as long as we've been doing it, we understand the range, right? And there is wide range.
Very.
So here in the state of Florida, and again, I'm not speaking to other states because different states have different rules. Some of them are really kooky and bizarre. There are some circumstances where some places where judges' hands are completely tied. I mean, I don't know, other than what I hear on the news and read in social media, I don't know what the law in the state of New York is. But my understanding about pretrial detention is that it pretty much doesn't exist. That means that a judge, based solely upon the booking charge, let me tie this backwards for a second. Last week when we talked about Arthur hearings, we were explaining about cases where because of the charge, the judge cannot issue you a bond in the state of Florida. But that is a minuscule percentage of
Right.
cases here in Florida. The exact opposite is what I'm talking about now in New York. Again, limiting this to my non-professional, non-licensed lay opinion. But my understanding is that the bulk of the cases in New York, they can't institute a bond even if they want to.
That's
Because again, the vast majority of cases are minor and they've eliminated bond for most of those cases. So what I'm talking about, where I'm going with all this, is a concept called judicial discretion. Here in Florida, judges, absent extraordinary circumstances, in the vast majority of cases, enjoy a great deal of discretion with regard to most things. But today's topic is jails and prisons, so we're focusing on sentencing.
Right.
And when it comes to sentencing, meaning you've been adjudicated guilty of something, right? Whether it's because you went to trial or you took a plea or you're pleading open to the court, whatever the reason, a jury came back with a guilty verdict, charges, lessers, whatever. For whatever reason, you are now standing in front of the judge, you have been adjudicated, and the judge needs to decide, what do I do with this guy? And here in Florida, as a general rule, they've got a lot of discretion. They've got a wide range of alternatives. So let me run you through this real quick so that you get the idea. We have what are called statutory maximums. So as we were talking about the different levels of offenses before, let me go from the bottom to the top. Second degree misdemeanors, which are the lowest level offenses in the state of Florida, are punishable by a statutory maximum of 60 days in jail. That means if you have one second degree misdemeanor, the most the judge can give you for that second degree misdemeanor is 60 days. But the least that the judge can give you is nothing. So the judge enjoys that range of discretion from 0 to 60 days. If we bump it up to a first degree misdemeanor, it becomes 364 days. So again, the judge has discretion from 0 to 364 days. Jumping up to felonies, third degrees are punishable by a maximum of 5 years, second degrees by a maximum of 15 years, first degrees by a maximum of 30 years, life by a maximum of life, and death or capital by a maximum of death. But there's a range. And the bottom of the guidelines, the low end of the judge's permissible range, varies based upon a set of factors, which we'll get into in a little bit. And part of what Ed and I and people who do what we do need to be aware of constantly right out of the gate is what is the client's exposure. So you start with that premise of the statutory max, and then you've got to figure out the statutory minimum. And then you've got to look at the facts and the circumstances of the case and figure out, based on your knowledge and experience, not only of the charges, but of the judge, of the client's personal paper trail, meaning their criminal history or lack thereof, and any relevant factor that you know of which will affect sentencing. And again, we'll go through some of those in a little bit. And based upon our math, the calculus that we do, we come up with the range. But when we really want to know the range, and I know this is boring as can be, it's like an insurance seminar, but I'm going to pop it up there anyhow. Andres, if you could, pop up the PDF file that I gave you. And what you guys are looking at now is the actual criminal punishment code score sheet. This is the document that is used by the state attorney's office and ultimately relied upon by the court after being fact-checked by the defense attorney to determine what an individual's range is.
You know I'm triggered right now, right? You know you've triggered me.
Go ahead.
I had to fill out thousands of these. Thousands.
Yeah, it's the bane of the prosecutor and defense attorneys. Look, you know, it's tough for us too because you can't rely on a prosecutor's scoring. You have to double check.
Michael, even if they mean well, it's so complicated that we make mistakes.
So I just want to run through, I don't want to go through everything on here. I'm not going to line item it, but I want you guys to understand how the math works. So every single charge in the state of Florida, for every statutory offense, there is a corresponding level assigned to that offense. It can start with the lowest possible level of 1, or it can go to the highest possible level of 10. Right? No, there's something lower than 1 because you have an M. Misdemeanor charges are actually lower than a 1. So all felonies go from 1 to 10 in terms of rating, 10 being the most serious, 1 being the least serious.
But the M only applies to priors. If you look at the sheet that you're looking at, you'll see after the box, it says primary offense. This is only used in felonies.
Right.
You'll see that one does not have an M.
But my point is every offense has a designated numerical score.
Right.
So it could be that a possession of cocaine scores the same as a simple DUI. It could be that an armed robbery scores the same as a vehicular homicide. Whatever it is, you get that offense level number, and that translates to a numerical value.
Correct.
Okay? Now, whatever your charges are, it starts with the most serious charge. The highest possible offense is your first numerical score. If you have multiple charges, then every other offense gets added to it at a lower rating than the first. And then after we go through your offenses, the next thing we hit up is what's called victim injury. So if there is an offense that involved an injury to the victim, then we have to determine whether or not it's fatal, whether or not it's a homicide, intentional, whether or not it's severe, moderate, slight. It could be that there's sexual penetration or sexual contact. Any injury to the victim also gets a numerical score. Then the defendant or the accused prior record comes into play. They say you never escape your past, they mean it. Although in Florida, you're only scorable up to 10 years after your last offense or the completion date of your last offense. But anything within that 10 years is going on your score sheet. It will get a numerical score. It will be added in. If it's older than 10 years, even though they can't use it on this score sheet, they can still consider it and factor it into any plea, and they will. But they can't use it for purposes of generating your number.
And remember, this is a score sheet that's used to tell the court what is the minimum
range
sentence him to. If he wants to take a plea, if he goes to trial and loses, aside from any kind of negotiation, if he went to trial and lost, the judge would have to have to set and shoot to the bottom of the guideline, unless Michael and I are.
We'll get there. We'll get there in a minute.
But generally, they're stuck with the bottom of the guidelines on the sheet.
So next we go to legal status. You can get scored for different types of actions. For example, if you are on probation at the time of your current case, if you escaped, if you were impeached.
You might want to tell Andres to put up page 2, right? It's on page 2, no?
Yeah, you could go ahead, Andres. Slip over to page 2 if you don't mind. Thank you. Then we go to community sanctions. Again, probation, community control, things like that. There are enhancements if there's a firearm or a machine gun or a semi-automatic weapon. Prior serious felonies. There are enhancements for law enforcement, drug trafficking, motor vehicle theft, criminal gang, domestic violence, adult on minor, sex offenses, no matter what, ultimately you add up all these numbers. It's kind of like doing your taxes, right? You're filling in all the numbers on the form, and at the end,
well, only difference is there's very few deductions on this one.
yeah, there are a couple though, and we're going to talk about taxes because I've actually got a couple things I want to talk about that are completely tax related here. Believe it or not, I'm bringing taxes into this.
Oh Lord,
You're going to love how I'm doing it though.
We're really going to put everybody to sleep.
Oh no, not the way I'm doing it. I'm doing it using Mike the Situation Sorrentino and Wesley Snipes, both of whom went to prison over taxes. Huh? You like that?
I do.
Okay. So anyhow, we come up with this number, and then there's a mathematical formula that we need to follow. We have to do a little subtraction and a little multiplication, but ultimately we reach what's called a net value. You get your gross score, and then we do a little math, and we come up with a net. And depending upon your net number, your bottom of the guidelines is either going to be 0 or X. If it's 0, then the judge does not need to give you 1 day of time in custody up to whatever the statutory maximum was. Could be a year, could be 10 years, could be 100 years, who knows, could be more. But the judge will have a lot of wiggle room. On the flip side, if your number comes up above the dividing line, which for whatever you want to know, it's 44. If you're 44, if you're above a 44, then what Ed said applies. That's the rock bottom that the court must give you. So if you score, if your net number is 45, that means you're looking at 45 months in prison at the bottom of the guidelines, up to whatever the statutory maximum is when we add up all of your counts together and figure out what that number was. So the judge can go anywhere in between there without any fear of appellate action. In other words, if the judge gives you 45 months, he's good. He's not going to be overturned on appeal, assuming the math was all right and there's no other issues with the case. We're just talking about the sentence. If, on the other hand, the judge goes up and decides your statutory maximum was 30 years, and instead of giving you 45 months, I'm giving you 30 years. If he's within the guidelines, same. Now, there may be some issues with regards to malicious sentencing, vindictive sentencing. There may have been some provable plea offers that were lower, and you may be able to argue the functional equivalent of what we in the biz call a trial tax. But be that as it may, the general rule is so long as the judge is within the guidelines, it's going to be a permissible sentence.
Right. Which, by the way, courts have determined that is not acceptable. Judges cannot sentence you based on a trial tax. So even if you go to trial and lose, the judge cannot say that had you not gone to trial, or let's say a judge offers you 5 years in state prison. You end up going to trial and you lose, and the judge gives you 10. Well, the judge has to justify why now they're going to do 5 extra years.
That's if the judge makes an offer. But if the state makes an offer of 5 years and the judge winds up sentencing you to 10 or 20 or 30, again, you may still have that argument if the court was involved in the plea negotiations. But, the judge is going to look back on the record and have to give written reasons as smart judge will do this in advance.
Because we're going to give pro tips, let's be honest. Most judges are ethical. Most judges, if they do change the sentence, it's what they usually put in their order or their ruling. I sat through the trial. They don't have all the information when they're taking pleas, but now they're seeing evidence coming out and things happen. They may have seen something that they didn't know about when the trial happened. You may have testified and the judge found that you lied under oath when you were testifying. So they're going to hold that against you. So listen, most judges know what they're doing. Most judges are not vindictive. So if you end up going to trial and you lose and you get more after trial, it's usually because something's going to come out that the judge can say, had I known this, I would have never accepted that plea offer. So don't think this is a freebie. It's not a freebie.
And that kind of goes a little bit, well, I don't want to run there yet. Let me scroll down, Andre, scroll down to the last page. If you would, thank you. What you're looking at here is a series of check boxes, and these check boxes basically line up with what we call mitigating circumstances or statutory mitigation or a downward departure. So there are some things that judges do not have discretion on, at least not patent discretion. They have latent, but not necessarily patent. So let's say, for example, that you get charged with aggravated assault with a firearm. That carries a 3-year minimum mandatory. If you are convicted of that offense, by law, the judge must give you at a minimum 3 years of day-for-day prison time without any gain time. Now, they could give you up to 5, but the minimum mandatory is 3. Trafficking offenses, drug trafficking, controlled substances, they all carry minimum mandatories, and the minimum mandatories vary depending upon the weight and depending upon the substance. But if you are found guilty of a trafficking charge, then you must get a minimum mandatory. So how do we get around these minimum mandatories? There are ways, and the ways are listed out in Florida Statute 921.0026, and you're also looking at many of them on the screen right in front of you. They're right there on the score sheet, and the reason that they're there on the score sheet is because they're used all the time. So, for example, if there is a, quote, legitimate uncoerced plea bargain, that's a way around the minimum mandatory.
Right.
A state attorney can say to you, look, I'm willing to waive that 3-year minimum mandatory and give you X in exchange for your plea. If that happens, that's it. Everybody's satisfied. Everybody walks away clean. But there are others. So I don't want to go through all of them, but I'll give you a couple of biggies that we would normally use. The victim was an initiator, willing participant, aggressor, or provoker of the incident. That is a situation that occurs in a lot of cases where somebody gets injured in a fight, let's say. Turns out that the injured party doesn't get arrested, but that was really the person who started the whole thing, pushed the whole thing, and made the whole thing happen. Even though it doesn't rise to the level of legal self-defense to get an acquittal or stand your ground, it is a basis for a departure. Now, in order to get that, the defense is going to have to prove it. The state bears the burden of proof in every criminal case, but if the defendant wants to seek a downward departure, the defendant has the burden of proving the facts that justify that downward departure. And the state gets the benefit of every doubt, so it's up to you to prove or plead your case. Another good example that we try to use when we can. The need for the payment of restitution to the victim outweighs the need for a prison sentence. So there are certain cases, many financial, but some physical. People get injured. There's no insurance. There's no money there. And the defendant has the ability to make payments if they're gainfully employed and they're working. But if they're not gainfully employed and working, ain't no way they're going to come up with a dime. A victim may say, you know what, I already went through the worst of this. I don't really feel like suffering for the next 5 years when this guy could be writing me a check every 2 weeks. So that's a good one, depending upon the circumstances. And then finally, another big one that we use is the defendant requires specialized treatment for a mental disorder which is unrelated to substance abuse or addiction, or for a physical disability, and the defendant is amenable to treatment. It used to be, back when I began practicing in 1991, you used to be able to argue for a downward departure based on drug and alcohol addiction and use. In other words, you could say, my client was so banged up, he had no idea what he was doing. He needs help, not jail. That was legitimate. The Florida legislature removed that. It is not legitimate. You cannot no longer use it. In fact, it's right there in the rule. It has to be unrelated to those exact words. It is unrelated to substance abuse or addiction. So if you do suffer from a major mental illness that's bona fide, or if you do have a physical disability that's bona fide, and if you are not treatable, it's specialized, it's not something that can be handled in jail or in prison, that may be the basis for a downward departure. But again, the burden is on the defendant to prove those things.
And you can still, Michael, just so they know, the reason that I think the legislator did away with the drug being on drugs or being addicted to them or any kind of narcotics is because we now do have drug court. And that's something that should, if it's going to be worked out, it's worked out before you take a plea in front of that judge. You get transferred to the drug court if you qualify. And so I think that's one of the reasons they got off. But again, pro tip, this is why you hire a good, competent, ethical lawyer who knows what all the routes, every possible chance and ability and routes that we can take to work your case out.
So one of the things that Ed and I have to do, and drug court's a great example of that, we have clients who don't know the system like we know the system. And as a general rule, look, I don't profess to be, some kind of seer. I'm certainly no Madame Chloe. But after 30 years in this business, I'm a pretty good judge of character, and I'm pretty good at reading my clients.
I know exactly where you're going, brother.
So
Exactly.
some clients are just not good candidates for drug court. Drug court's a great deal for them, but they ain't gonna make it. They're just not. It's too regimented. It's too restricted. It's too demanding. There's zero tolerance. There's no wiggle room. There's no gray area. You're either in it or you're out. It's that simple. And if you go in and get bounced out for non-compliance, you can seriously hamper your ability to defend the case. So a experienced attorney like Ed or I, part of our calculus is not only going to be what is your exposure, who is your judge, what is that judge's tendency? And by the way, that has a lot of bearing on the prosecutor, right? Because I don't care if you have the toughest prosecutor in the world. If you're in front of an extremely liberal judge, that prosecutor's playing with one hand and one leg, doggy tied behind their back.
And they know it.
And they know it. They learn it quick. So they lighten up because they know they're not going to get away with it. On the flip side, if they're in front of a very tough judge, we know it. So we're able to give this dynamic to the client, present a larger, more global view of the situation than just what presents on paper. And the same logic applies to sentencing, probation versus incarceration, and local jail versus state prison when you have an option. Because we're offered that very frequently. State attorneys love, I don't know why they're married to prison. For whatever reason, they tend to love prison. They like a year and a day. I'm sure you have an explanation for that.
I do. But the ones who do that know something that I am not going to divulge in public.
Okay, fair enough.
They are the ones,
keep your secrets, Mr. Man.
They are the ones who learned what I learned as a prosecutor, and I know exactly why they do that, but some don't. And again, it's not. I have to represent my client, Michael. Right? We have to represent our clients.
And every client is different, and every client's needs are different. And so, if you're sentenced to local time, here's one thing we can tell you for sure: you're local. If you're sentenced in Dade County, you stay in Dade County. If you're sentenced in Broward County, you stay in Broward County. If you're sentenced in Monroe County, you stay in Monroe County. If your family happens to live there, they've got easy access to you. They can visit you. They can do virtual visits, in-person visits. They can put money in your commissary account. They can bring the kids, whatever it is that you guys decide as a family is appropriate, you can do. But if you get sentenced to state prison, no judge has any control over Florida Department of Corrections classification and housing situation. So all they can do is sentence you, and they can make a recommendation. So they could say, okay, Mr. Haber, I'm sentencing you to a year and a day in state prison, and I'm going to make a recommendation to Florida Department of Corrections that you be placed in a Southeast Florida facility so that your family can visit you. But that has no, it may or may not persuade, depending upon their own internal considerations. They may not even read the piece of paper. Who knows? But at the end of the day, here's what we do know. You can be sentenced, you can be classified and designated and housed in any state facility anywhere in the entire state of Florida, in the 64,000 square miles of the state of Florida, however big this state is. So a Miami person could very easily find themselves in the panhandle, making it much more difficult for the family to visit.
Correct.
And that's a very important consideration for us when we have a client who's going to do time. And unfortunately, some of our clients are going to do time. No matter what we say or do, we can be as creative as we want. And part of our job in those cases is to be creative to mitigate those sentences down. Because the same exact charges for different people will work out differently. There is no uniformity in sentencing. People argue that there should be. I argue there shouldn't be. I believe in judicial discretion.
One of the biggest things that comes up, Michael, it's one of my pet peeves, is when you hear clients say, well, I know a guy, or I was in, and he got X, and it's the same exact charges. Look, there's three humongous general problems with that. Number one is you don't know the facts of the case. You don't really know what the facts were of that person's case. Number two, you don't know who the prosecutor was. Don't know. Some prosecutors are harder. Some prosecutors work harder. Some know more. Some are afraid of going to trial and some are not afraid of it. There's a lot of things in the mix. But lastly, I think one of the biggest issues is you don't know who the judge was. And
Hang on one second, Ed. Andres, you can pull that off the screen. I apologize.
Michael already mentioned that. When you're in front of a judge, okay, so Michael is representing somebody. I'm in front of a judge that I used to be in front of, Judge Leonard Glick. Leonard Glick was known. Remember Lenny? Lenny Glick was known. If you went to trial, he was going to scrutinize it and he was going to find reasons to go, boom, max. So you're looking at 30 years of state prison and you come into Lenny Glick's courtroom. I know that I can offer Mike 5 years if I got a good case. Why? Because Mike's going to look at his client and say, you stupid? You don't take 5 years. This guy's going to nail you. There's other judges who I won't say any of their names. I love them. I don't judge them. I don't criticize them, but I don't want to blast them. There are some judges that you're in that division. You know, you make an offer of, a withhold court costs, and they end up going to trial. You get a conviction on a 30-year first-degree felony, and after the jury finds him guilty, the judge still offers him a withhold court costs. So you're thinking, it's a waste of my time. So yeah, you're going to get a better offer in front of that judge because the prosecutor knows it doesn't even matter if I go to trial and win. He's still going to give him what I offered him in the beginning. And then the attorney on the flip side knows, listen, if we don't take 5 years on this one, I know it sucks, but if you don't take 5 years and we lose, you're going to get 30. So you can't go by that, guys. Trust me. That's why you hire us. We know what we're doing.
I want to talk a little bit about, I used a racy image about Jussie Smollett in our promo today. And I'm sure most everybody knows who Jussie Smollett is, but just to recap, he's an actor who was recently convicted after making a police report claiming that he was the victim of a hate crime in Chicago, having allegedly been attacked by he's a gay black man who claimed that he was attacked by white men wearing MAGA Trump hats who put a noose around his neck and used racial slurs and basically threatened his life. And as it turns out, it was a hoax. And even though he insists to this day that he did not make it up and he's not crazy and he's innocent, he was recently convicted of 5 of the 6 counts that he was charged with. He is now a 5-time convicted felon in the state of Illinois. And the judge sentenced him. I don't know. I mean, a lot of the media did not cover the sentencing. I happened to catch some of it. And the judge went on a pretty, I would say, severe tongue-lashing tirade on Mr. Smollett or whatever his name is, Jussie, basically saying that he had committed perjury for 4 hours while sitting on the witness stand. And he had done irreparable damage to race relations in this country, and that he was an affront to actual victims of hate crimes. It was a tirade. His judge
Michael,
really.
Listen, he said something else that you left out. I don't know if I was zoning out a little bit there, but the judge was correct when he said literally from this day forward, lying about a crime is going to be referred to as a Smollett or a Jussie.
Yeah, he went off on him. He went off on him. I would say that's as bad as I've ever seen any judge go off on anybody. However, he got convicted of 5 counts, each of which carried a 3-year maximum penalty. Now, because they all were part of the same course of conduct, and again, I'm not an expert on Illinois law, but if it had happened here in Florida, and I believe based on what I've heard in the news, that the rule is the same, he could not be consecutively punished for each of those counts. He could be concurrently sentenced to 3 years on each count, which means he would get 15 years, but they would be served together in one set of 3. However, he didn't get 3 years, he didn't get 2 years, he didn't get 1 year, he didn't get 6 months. He got 150 days. And my understanding, again, I'm not an expert on Illinois law, this is what I have gleaned from the media, is that it is a day-for-day credit. So he will serve 75 days, minus the day he already served before he posted bond. So he's going to serve 74 days in jail. Now, he also got hit with 2.5 years of reporting probation, 125,000 or so in restitution, and a fine. But it's interesting that the judge tore into him as harshly as he did, yet didn't slap him as anywhere near as hard as he could in terms of jail time. Thoughts?
For sure, he didn't slap him as hard as he could. And I think if you, a lot of the media didn't cover the evidence. I mean, there's a videotape of them preparing. Where Jussie shows how he wants him to put the noose around his neck. And I mean, come on, man. I mean, I don't know. I don't know if they went to trial because Jussie forced his lawyers to take it to trial, because that happens sometimes.
Well, and there may not have been a plea offer either. The plea offer may have been even worse than the sentence.
Maybe. And if that's true, that's another criticism that I have of prosecutors. Sometimes they don't understand that, your job is to do justice. Your job is not to just go to trial and win so you can brag about how you win. Your job is to do justice. And sometimes there's very few times in my career, I think in anybody prosecutor's career, where they can honestly justify saying the offer is the max. Okay. Maybe a mass shooting. I can see that. There's some situations, some types of rape, some types of sexual batteries, some situations, but a situation like this, I don't know how you could justify the max. I don't know what offer they made, if any.
I don't know either.
But in this case, if Jussie's the one that forced this to trial, then he got the tongue lashing he deserved.
But he didn't get the sentence.
Overwhelming evidence.
But he didn't get the sentence.
No,
and that's kind of the point. So the judge in Illinois must have had a similar discretion as the judges here in Florida enjoy in terms of making that ultimate decision of what's just, fair, and appropriate given the facts and circumstances as known to the court. Mm-hmm. So let's take another example real quick, okay? Let's talk about Laurie Laughlin and Felicity Hoffman, okay? Laurie and Felicity are a couple of housewives, real housewives, who got popped in the college admissions federal court scandal a couple of years ago, back in 2019 and 2020. Felicity Hoffman pled guilty almost immediately. Laurie Laughlin dragged the case out for the better part of a year, a little bit over a year, defiantly going on television, standing in front of the cameras, proclaiming her innocence, saying that she's going to trial, blah, 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 blah. Both of them wound up taking pleas. Again, one did it much quicker than the other. Felicity did it within the first 30 days. Laurie waited well over a year and taunted the government in the process. Their culpability, that is, the allegations that were alleged against them, are slightly different. Again, Felicity less culpable in a way than Laurie, at least arguably. I mean, I guess at the end of the day, using fraudulent means to get your child into a secondary, college is in and of itself the same conduct. But Felicity was accused of paying $15,000 for bogus SAT scores. That was what she was accused of, and that's what she pled to. Laurie, on the other hand, was accused of and pled to paying $500,000, that's $500,000, to guarantee her daughter's admission into a specific university. But not only was it a much higher payout, in order to accomplish the objective, she had to take pictures of her kids, her two daughters, allegedly on crew vessels, which are those rowing things. The kids had no crew training. They never crewed in their life. It wasn't what they did, but they posed them up for the pictures because that was the mechanism that they used to get them into the University of Southern California or whatever it was, UCLA or USC. It was somewhere in Southern California. And the idea was to get them in on the crew team. And even though they had never crewed, basically she paid $500,000, took some pictures, and had somebody with the ability manipulate the system to put the kids into the college.
That was her defense, that it was somebody who does this for a living, and they hired the guy, and they didn't know that was illegal. But it's like you say, Mike, if they're telling you to take pictures of your kid rowing, when
she knew her kid. Look, she knew her kid wasn't a crewer, was never on a crew team, and had never crewed. And she also knew that she was paying somebody an exorbitant amount of money. Look, to argue that she didn't know what was going on would be ludicrous, which is why she didn't go to trial, and she wound up taking a plea. She pushed that envelope as far as she could. But here's the interesting dynamic. Now you know what these two different ladies did. Here's the sentences. Felicity got sentenced to 14 days in jail, a $30,000 fine, 250 community service hours, and 1 year of probation. Okay? 14 days in jail, $30,000 fine, 250 community service hours, 1 year of reporting probation.
And Hollywood loved her, so they gave her another film.
Laurie got 60 days in prison, $150,000 fine, 100 community service hours, and 2 years of reporting probation. Her husband, and Felicity's husband, who, by the way, is William H. Macy, right? He wasn't involved in this. He never got indicted. But Laurie's husband did get indicted, and he got 5 months, not 2. He got 5 months, a $250,000 fine, 250 community service hours, and 2 years of probation. So why the discretion? Why the diversity? Why the different sentences? And by the way, why are they only getting 14 days and 60 days for this conduct?
You're asking me?
Yeah, I'm asking you.
Yeah, well, one question we need to know first, was it the same judge? Different judges?
No.
Different judges. That's the first problem.
Yep.
That could be the answer right there alone. Secondly, Mike, I think it goes to what you said. Again, when I was a prosecutor, we have an ethical obligation to do these, to do the right thing, to be honest with you, always. But one of the things you take into account, at least I think prosecutors should take into account, and judges, I'm sure, do as well, is what is your odds of recidivism? And people who accept responsibility for their actions tend to have a lower rate of recidivism. People who continue to do what's her name, Laurie, whatever her name is, did, right? Hoffman, let me put it backwards. Hoffman tends to show you that she's accepting responsibility for her actions, and so her chances of recidivism are lower, so perhaps the punishment can be lower. Somebody continues to fight and argue, which is their right, but when the judge sees that there was overwhelming evidence against you and you just were doing it because you were just a stubborn, hard-headed ass, they're thinking, you know what? I need to come down a little harder on this one so that they learn their lesson. So that could be the other reason. And it's legit, because one of the things that they look for in the criminal justice system is, have you accepted responsibility for your actions? And that is a legitimate reason to sentence somebody to less, or vice versa, sentence them to more. That's one of the things that a judge can say in trial, right? Well, the offer was 5 years, but I sat here and saw all the evidence now that it went to trial, and this was overwhelming. And I'm sitting here asking myself, why did you even go to trial on this? Why did you take the plea? Well, I think it's because you just don't want to accept responsibility for your actions. The judge can do that, and that's not appealable. So I think in this case, Mike, that's probably what happened, that the judge was sitting there saying, you know what? This one, we needed to force her to come and drink from the well. Maybe she needs to sit in jail for a little bit longer so she thinks about it ever doing something like this again.
It's funny because as a defense attorney, it's hard to believe that I look at these things and say, why didn't they get more time? I mean, I would have banged Laurie so much harder than this judge did, but that's me. I don't know. Let's go to.
Obviously, their attorney did a good job in letting the court know that it was not because she was defiant, that there were mitigating factors, that blah blah blah, whatever it is. And I'm not saying blah 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 like we make shit up.
I think you're right. The attorneys did a bang up job, because there's no other explanation unless they were paying off the judge like they were paying off the admissions committee. I can't think of any other reason why the judge would have gone so lightly on her.
I'll be honest with you. And I'm not saying we make anything up, because I would never do that, and I don't condone anybody. But Mike, there have been times where I've walked in and the judge has looked at me and said, finally, so now he wants to take a plea, Mr. Martinez. Why? And I've literally looked at the judge and said, because I had that come to Jesus conversation with him, Your Honor. I had to help him understand.
And most of those judges know that anyhow. They don't need to ask the question.
No, a lot of times they're doing it just to make sure the client understands that this is serious, and you owe your lawyer a debt of gratitude for making him convincing me as a judge that I should take this plea. So yeah, I get you. I agree.
So that's two ladies, Laurie and Felicity. Let's talk about two guys. Let's talk about Mike the Situation Sorrentino and Wesley Snipes. Both of these guys were convicted of tax-related cases. Let me give you a little bit of history as to each. The Situation, he's the guy from the Jersey Shore. Apparently, between the years 2010 and 2012, he failed to pay taxes on $8.9 million. He was charged with tax evasion, structuring, falsifying records. Structuring is a pretty serious offense, by the way. Structuring is where the government can prove that you took physical overt acts to hide the trail of breadcrumbs and the evidence of your crime. So, for example, let's say that you want to do some money laundering, but you know there's a rule that if you deposit more than $10,000, the bank's got to report it. So instead,
it's called a suspicious activity report, a SAR.
So instead, you make $7,000 deposits every day, or you go to 3 different banks and you make 3 different $7,000.
3 days in a row. 3 days in a row, you deposit $7,500.
You basically structure it in such a way that you believe you're going to avoid detection, and therefore nobody's going to write that SAR, and you're not going to have to worry about it. So anyhow, that was Mike the Situation. Wesley Snipes was similar, a little bit different. Wesley was arrested for avoiding $7 million in taxes between 1999 and 2004. He had felony charges for tax fraud and conspiracy, but what he got ultimately convicted of was not filing tax returns. The Situation took a plea. Wesley went to trial. The Situation's case, now again, we're talking about, not too much difference in money. I mean, for me, it's a huge difference in money, but, for Ed, it's pennies.
Oh, yeah.
The difference between 8.9 and 7 million.
The other day, I found $1 million cash in my pocket of my pants. I was like, wow, look at that. I forgot I put that there.
And you didn't even invite me to dinner. So Mike the Situation, he's got 8.9 million in taxes that are at issue here. And he winds up taking a plea. He gets sentenced to 8 months, 2 years probation, 500 community service hours, 120,000 in restitution, and a $10,000 fine. Okay? Wesley goes to trial. Wesley is acquitted of every felony count, but he's convicted for the misdemeanors. And he winds up getting 3 years in federal prison with, I can't read my own notes, 3 years in misdemeanor sentences, plus back taxes, whatever. So why does Wesley get 3 years and the Situation get 8 months? Essentially the same charges, essentially the same amount of money. I mean, you could argue one's black, one's white. Maybe that's got something to do with it. Wesley Snipes argued it. His lawyers played the race card.
Mm-hmm. Arguably, now again, I didn't represent Wesley or the Situation, but I remember when that happened with Wesley Snipes. I remember reading about it. I don't remember if I was in law school or when it was. What year was it that he was sentenced?
I don't remember the year of the sentencing, but the tax situation was from 99 to 04.
Okay, so I was at the state attorney's office probably when it happened. I remember that, if I'm correct, part of the problem was that Wesley Snipes never denied intentionally not wanting to pay the government. Not that he forgot to file taxes.
Snipes' defense was that he was simply following the advice of his accountants, who, by the way, were also charged and convicted.
No,
more serious charges, by the way.
That may have been what he ultimately argued at trial. But I remember when it first came out, his argument was that he was a sovereign citizen. He was one of those sovereign citizen
Right.
idiots.
That was his Laurie Laughlin publicity on TV before court bullshit. But in court, he did not go with the sovereign citizen. In court, he went with the advice of my accountant's defense.
And if the advice of the accountants was, I don't have to pay taxes,
that's what he argued.
That's not going to fly. No accountant on the planet would say that to him. And so
Well-
I'm sure the judge said, you know what you are? You're a guy that's a horse that we led to water, and you just don't want to learn. See, I'm sure that the situation was different. I'm sure one of the reasons he got in trouble was the falsifying of things. But, you know, to come in federal court, especially on a tax issue, they're not going to put you in prison if you just don't, you know, make a mistake or you were working it out or it was complicated. You know, as long as, again, you're contrite and you understand that you say, hey, I understand that I was supposed to pay taxes, Your Honor. I didn't intentionally avoid to pay taxes. You know, I got into a car accident. I was in a coma for 6 months. And when I came out, I was doing therapy. And the last thing on my mind was paying taxes. Okay. But to just walk up and say, you know what, Judge, pardon my French, fuck you, I'm not paying. What do you think is going to happen? Of course they're going to slam you because you haven't learned your lesson.
Well, whatever the case, that's what happened to these guys. And I think the takeaway from it is a lot of it has to do with lawyering. The smarter your lawyer, the more experienced your lawyer, the more sensical your lawyer, and the more you listen to your lawyer, the better the odds are going to be. So some of you don't want to go to jail for a day. I don't blame you. But some of you are better off in jail for a day than you are on probation for a week. Some of you are better off in jail for a month than you are on probation for a year. Some of you are better off going to state prison for a year and a day than you are being local for 364, or vice versa. Better off being local for 364 than going to prison for a year and a day.
I had a client, I think I told you the story, Mike. I had a client who got arrested for, I think it was it was 5 different counts of fraud, 5 different cases. So it was 5 different charges, 5 different case numbers, 5 different cases. And when he got arrested, there were 3 more investigations still going on, and they just hadn't gotten around to pull the trigger and have him arrested. Well, the prosecutor gets the case, and one of the cases was really bad for them, and I knew they were going to lose that case. So I filed a speedy demand. We went to trial, and sure enough, before we even picked the jury, they had to dismiss it. So we were stuck with 4 more, right? And the state said I have 3 more cases that I could charge him, but I'm holding off. I won't charge him with that if we can agree to a plea. He was sitting in jail because he had committed all these crimes. He was out on bond when he got arrested on another one. So whatever. The judge was like, I'm not letting him out. He's sitting in jail locally over at Metro West, which is the nicer jail. Family visits him every weekend. The guy had even started his own poker game, Michael. Gambling in jail. He was like the kingpin. They were apparently playing poker with commissary money and cigarettes or something. I don't know. I said, listen, you got a cushy thing. He said, I've speeded up. I want to take it. I said, look, right now, they're offering you 5 years of state prison. I might be able to get it down to 4. Let me just show. I've talked to the prosecutor about some things. I've explained to him why one of the cases is not as strong as he thinks it is, but I have to show, because this was an economic crimes case. It was in the unit that I used to be in, but he was one of the newer guys there. So I was trying to show him, you got to follow the money. Get me a subpoena. You're thinking my guy committed a crime because he did this, but you haven't seen where the money went. That's where the crime was committed. That person. So I told him, if I can get that case out, then you're only stuck with 2 now, or 3 or whatever, and I can get him down a little less. Meanwhile, why are you in a hurry? What Michael said, you're sitting in jail where everybody visits you every weekend. You go to state prison, you might go to Pensacola, and he had a daughter. Long story short, he didn't like it. He hired somebody else who sold him a bill of goods, song and a dance, blah, blah, blah.
Adios.
About 6 months to a year later, I think it was sometime between 6 months to a year later, he ended up taking a plea. Now the plea was 8 cases, 10 years of state prison. Why? I know that it's desperate. I get it, man. You're just desperate, especially if you've not been in prison before. You're sitting there desperate, wondering what's going to be the outcome of your case. But either way, you're going to be in jail, so just relax. Most of the guys in the local jails don't want to cause trouble because they've got pending cases, and they realize if they cause trouble, it's just going to make it worse. Well, you go to state prison, you're going to be up there with lifers. Lifers have nothing to lose. They're not getting out, and they got nothing to lose. So to them, it's fun to pick on you. It's fun to see you bleeding. It's fun to mess with you. It's fun to take your shit from you. It's fun to make you look like a little scared pansy in the middle of a jail. They get off on that because they're not going anywhere anyway. So just take the advice. Sometimes you're better off sitting here. And the prosecutors know it. Some of them get it, and they get it, and they know, okay, look, let your guy sit in there a little more. We'll make him a prison offer, but it'll basically be credit time served. Sometimes you get that, and I try to explain that sometimes to my clients. The prosecutor's doing you a solid, man. He's willing to give you basically what's going to end up being credit for time served. Just keep your shirt on and stay there. Got to listen sometimes.
So we're out of time. I wanted to do a few more things, which we won't be able to do, but I did want to talk about the nature of jails and prisons. I guess we can do that on another show. Maybe we'll show a few clips from Oz, one of my favorite all-time series. But I just want to leave you with this following thought. There is life after jail for many people. Depending upon your situation and your circumstances. Ed and I don't want anybody to go to jail. We want to keep you out. We want to do our best to mitigate your case or beat your case, but not every case is mitigatable or beatable. And so I just want you to know that as I'm looking through, and I was looking through some celebrities, who have served time, and Robert Downey Jr. is a great example. He spent a year in state prison after parole violations for a boatload of drug charges, and look at him today. That was in the years 1999 and 2000. Mark Wahlberg, there's another one. He was sentenced to 2 years in prison for crimes of violence. Actually, I think they were hate crimes. And look at him now. Sean Penn, Christian Slater. I mean, I could just go down the list of people who and pay good money to watch their movies. And
some of them, this happened to them before they became celebrities. It's not like they got a gift because they were a celebrity and went to jail.
And the reverse holds true too, right? I mean, I don't know the guy's name. I could look him up at some point, but there was that very handsome guy that somehow he was in some prison picture and some scouting agent saw the picture and they wound up hiring him as a male model.
Oh yeah, there's another guy. I forget his name, but if you've seen him in a lot of good movies where he actually started acting in prison.
Danny Trejo.
Danny Trejo's one of them, but there's two. Yeah. Danny Trejo's one of them. He was there for murdering, I think, a guy.
So anyhow, we're over time, but my point is, look, listen to your lawyers, hire the right lawyers, always let your lawyers explore everything. Don't come to conclusions about your case until you've had an opportunity to vet it. And if you don't trust your lawyer and you want to get a second opinion, that's fine. Go ahead and do it. We're not going to be insulted, especially somebody like Ed and I, who are very confident that what we're telling you is spot on accurate. The only thing we have to worry about are the lawyers out there that are not as ethical or experienced, who are going to bullshit you and lie to you because they want to get into your pocket, but they don't care about what happens after they turn your pocket inside out.
Right.
With that said, it's Pie Day. Enjoy some pie. Pecan pie, apple pie, cherry pie, blueberry pie. Any pie you want. Enjoy.
Any pie? Any pie at all?
Any pie at all, Edward.
You might have some pie tonight.
You have free reign. You have free reign. All right, folks. Thank you very much for paying attention. I apologize we went a little bit over. I don't know that we're going to have a show next week because both Ed and I have trial calls next Monday. But we'll let you know. We'll be in touch. And if we can't do it, we'll see you the following week. Either way, we look forward very shortly again being back at your service. Thank you again for your time. Edward, thank you.
Thank you, man.
Andres, thank you. And we'll see you all soon.